you and I last saw each other in New Zealand when I went there to sit down with Kim. The judge has now said there is overwhelming evidence to support him being extradited to the United States. And the evidence in favor of Kim is short of undermining the case. What's your reaction to that?
Well, we think the court got it wrong. We had Professor Lawrence Lessig of Harvard University give an opinion where he basically said, in his opinion, that the U.S. case lacked merit and was unreliable. In order to extradite somebody from New Zealand under a United States-New Zealand treaty, you have to show dual criminality. It's a violation of U.S. law and a violation of New Zealand law. Well, they're trying to hold Mega Upload responsible for the acts of its users. That's called secondary copyright infringement, and there is no criminal statute for secondary copyright infringement in the United States. And there's actually an overt safe harbor in New Zealand that protects ISPs from criminal liability for user-generated content. So we look forward to going to the appellate court. This is not only an issue important for Kim Dotcom, but important for all ISPs to avoid a chilling effect on them.
You've already started the process of an appeal,
yes,
right?
Yes.
Are you going to do anything differently this time around?
Well, that remains to be seen. Those things go towards legal strategy. But I think that the record is clear. I think that this court, in a very long opinion, spent only about a few paragraphs on the notion that there's a safe harbor in New Zealand that protects ISPs. It's an important safe harbor. Right now, this is allowed to stand. A prosecutor could just use their discretion to heckle policies at an ISP because they don't like, say, a repeat infringer policy, and just prosecute them. They may lose, but the interim effect of prosecuting somebody itself is a victory. And we think that extends the copyright monopoly way too far.
Now, Kim and I had a very in-depth conversation when I was in New Zealand, and one of the most fascinating answers, I thought, was his response to my question, is he scared? Is he scared about 88 years in prison in the United States? Take a listen.
I'm not scared of anything, really. Everything that happens to me, I try and make the best out of it. I would say I know this sounds crazy, but I don't know fear. I don't understand fear.
How's he taking this?
Well, he's taking it well under the circumstances, and we have to take a look at what happened to date. There's been a buffet of government abuse, from the Prime Minister having to basically say he's sorry for illegally spying on Kim Dotcom in this case.
A raid on his home?
A military-style raid on his home, to a situation where the United States was found guilty of illegally taking data offshore, and then the takedown of Mega Upload, leaving innocent users without wedding photos and things of that nature. So he's taken that well. It's no surprise that he's taking this situation well. And when you have a scenario where Professor Lessig is at least disagreeing with other experts, how could a layperson like Kim Dotcom have the criminal mindset when the experts themselves disagree?
Now, one of your arguments is that Mega Upload isn't different from any other file sharing service, just like Dropbox. But then why isn't the U.S. government after Dropbox?
I think what's going on right now, it's clear. They're trying to use optics to go after someone they don't like. They're using the discretion that they shouldn't have to go after someone they don't like. There should be bright lines. The bright line in New Zealand is the ISP safe harbor. The bright line here, as articulated by Professor Lessig's opinion, is that you can't hold cloud storage providers criminally responsible for the acts of its users. At most, that's a civil claim.
Now, I want to dig into this comparison to Dropbox, because Dropbox says that they have several mechanisms in place to limit or prevent privacy, download limits, and such. And the other thing is that it's free. If Mega Upload was basically charging users for content that they didn't own, how isn't that illegal?
Well, that's the optics. That's what the prosecution wants society to believe. But just like Dropbox, which charges for storage space, Mega Upload charged for storage space. The prosecution is trying to conflate that to charging for actual works. And so Dropbox should be worried, because all that happened in this case was the prosecution heckling things like repeat infringer policies, heckling communications discussing repeat infringer policies, putting it into this optically bad package, ignoring non-infringing uses, And basically, the court bought into it without doing any kind of heavy legal analysis.
Kim Dotcom is often associated with these extravagant displays of wealth. We saw the mansion, we saw the cars. People don't often get to see his 5 children, which I got to see when I came to visit. But I wonder, what's it like working with Kim Dotcom?
It's like working with a combination of the old comedian John Candy, the late John Candy, and probably Steve Jobs combined into one person. He's an incredible innovator. He's somebody who can get people together to create great technology. He's extremely funny, and so it's a wonderful combination.
Now, you and I have talked about this a lot, and you've said, if anything, this should be a criminal, if not a criminal. This should be a civil case, not a criminal case.
Yes.
But if it should be a civil case, isn't that an admission of some kind of liability?
No, because in the civil case, there's this kind of weighing or calculus that goes on. YouTube was sued, and if YouTube didn't have the funds to fight back, YouTube would have lost. But Google had tens of millions of dollars. They put up their defense, and they won. Here, it's the same sort of situation. We could tolerate the downside being money, but to have someone to have to go to jail for over 80 years, and they're using the criminal laws to freeze all his assets, so that if he were to come here, the world should know he will not have a dime to pay for lawyers. And so they're using all these things that are only available in a criminal case to make an uneven playing field. There's no admission of liability. We're simply saying that the theories they're putting forth are the types of theories that civil cases have against Grokster and Napster.
And you think this case will go all the way to the New Zealand Supreme Court and could take until 2020 to be resolved?
It absolutely could, because the public policy issues are so important. What we have, if it's left to stand, is copyright extremism. It's very anti-business, and we think the Supreme Court, like they already did in this case, will take a hard look at this and hopefully provide a check and balance on this type of government abuse.